request and was ready to speak to us and impart his knowledge with all of us with a very short notice. Mr. Rajmani Verma.
Thank you, Shruti ma'am, for giving me opportunity to share my views on the PIL, which is a very limited stream of litigation. Basically, the public interest litigation, as we understand from the lawyer's point of view, it's not so much commercially viable option for the lawyers, especially unless you are appearing from the other side. Normally, what happens when the constitution came into being framed, at that point of time, the only contemplation or the consideration which was there in the minds of the framers of the constitution was to look into the interests of the republic, make a constitution for the public, by the public. So ultimately, the public's interest was taken into consideration since the inception of the constitution. Now, as we look at the constitution, we have had Article 14, Article 21, then state directive principle of state policy, Article 32, whereby you could invoke your fundamental rights in Supreme Court of India. Then we had Article 226, which had a bundle of rights, including the writ petitions, that five writ petitions, five writ petitions that we know of. Now, as we started off, in civil litigation, I'm talking about from that perspective, the broad guidelines which were available at those times were divided into two parts, either a writ petition or civil litigation. In case of enforcement of personal right, as regards any contractual or family matters or private matters, the litigant had the option to go for civil litigation. In the CPC, and the moment you go for civil litigation, of course, the CPC will come into play. Apart from giving right to the individuals to agitate their rights in the court, civil court, there were provisions for including the rights of other similarly placed persons having common interest. And that provision we can find in Order 1, Rule 8 of the CPC, which is popularly called as representative suit. But when we look at the writ petitions which existed as initially when the constitution was framed, there is no such concept of representative writ petition being filed in the court. So the only remedy which was available to the individuals whose fundamental rights were infringed, or any government department or any statutory authority did not follow the procedure or exceeded the jurisdiction or did something which were not in the jurisdiction of those authorities. So the individual writ petitions, private writ petitions could be filed. There was no concept of anybody going to the court saying, look, I am the representative of the section of the public and I have this kind of remedy or grievances which I want to get it redressed. Therefore, this concept of public interest litigation evolved over a period of time. And much after 20-30 years, especially started with the judgment of Bhagwati in the matter of SP Gupta versus Union of India, somewhere in 1979. And in this judgment, basically the entire scope of the public interest litigation was summarized. I'll just read out those relevant provisions and what the observation of the Honorable Supreme Court, so that we all can understand going forward during the course of my discussion, as I'll be talking, what exactly is the scope of public interest litigation as propounded by the Honorable Supreme Court. I'll just read out. Where a legal wrong or a legal injury is caused to a person or to a determinate class of person by reason of violation of any constitutional or legal right, or any burden is imposed in contravention of any constitutional or legal provisions, or without authority of law, or any such legal wrong or legal injury or illegal burden is threatened, and such person or determinate class of persons by reason of poverty, helplessness, or disability, or social or economically disadvantaged position, unable to approach the court for relief, any member of public can maintain an application for appropriate direction, order of writ in the Honorable High Court under Article 112 to 6, and in case of breach of fundamental right, then they can approach under Article 32 before the Constitution, before the Supreme Court, seeking judicial redress for the legal wrong or legal injury. So therefore, thereafter, many other judgments came up in the domain of defining what the PIL, what the scope of PIL would be. But more or less, this definition given by the Honorable Justice P.N. Bhagwati in the case of S.P. Gupta and Union of India, the position has remained as it is. No change. Concept has remained unchanged. Now, I'm coming to the second portion. What is a PIL? As we understand from public interest litigation, we all can understand very good that anything that litigation is initiated for the benefit of public interest is a public interest litigation. So where do we go? So the only two forums which are available for redressal of public interest litigation is Honorable High Court as well as Honorable Supreme Court. Now what is a public interest? We have to define, we have to understand. In fact, it is very evolving concept from pollution, terrorism, road safety, construction hazards, any other matter, for example, environmental issue. If you would recollect in the case of women harassment at workplaces, there was a Vishakha guidelines. These guidelines came up only because some PIL was filed. The Honorable Court had taken up the suo motu cognizance of the concept, and they came up certain guidelines and they were framed. Likewise, in the matter of bonded labor matters, neglected children, non-payment of minimum wages, atrocities of women, food adulteration, maintenance of heritage structure. In case of, for example, in the case of MC Mehta versus Union of India, where because of the so many factories which were emanating foul fumes and everything, as a result of which there was a problem in the color of the Taj Mahal was getting tarnished or becoming yellow or something, and therefore all the industries which were on the banks of river Ganga, which were close by, they were all removed. And likewise, the same concept was extended to various other cities or the banks, whereby similar orders were passed. So ultimately, when I say this, what is a public interest? So publics, definitely we are social human being. Anything that matters to us, and whereby something which is not going right and which is harping the interest of public at large, not just a small portion of the section of the public, but even considering the population of India, even a section of public also would be a drastic. So therefore, the concept of public interest is ever evolving. And more or less, there's no ambiguity with regard to what could be the public interest, what could not be the public interest. There's no dispute about that. Now, coming to the public interest, who are the people who can file or initiate the action under the public interest as a public interest litigation? Number one, we must have heard of the cases where, from the newspaper articles, the courts have taken suo motu action and cognizance of the fact. For example, we see the COVID situation when the COVID vaccination was not streamlined at some time, and there was some chaos in the matter of the supply or non-supply of oxygen. Based on the newspaper articles, the court had themselves taken suo motu action. That is also a public interest litigation. Number one. Second, so therefore, the first part is the court is itself entitled to take suo motu cognizance of any matter or incident which is harping the interest of public, and that can be brought within the purview of public interest litigation. This is part one. Part two, there was a case when a prisoner who was inside the jail, of course, and he was subjected to barbaric treatment by the jailer, and then he was able to write a letter to the Chief Justice, as a result of which, based on that letter itself, it was considered to be a PIL, converted into PIL, and the inquiries, judicial inquiry was taken place. In the case of bonded labor, there's so many such examples where the court takes cognizance simply on the basis of a letter or postcard written by a common citizen addressed to the Chief Justice directly. Second, so these are the two things. And now, as a lawyer, ultimately we come into the third category, where some kind of group of people, they come to us and they say these are the problems, we feel that something should be done in the society, in the interest of organization, in the interest of section of society, to curb any malpractice or any menace which is prevailing in the society, and those things come to the lawyer. So we fall into this category. So what we as a lawyer are supposed to do? And apart from any client who coming to the lawyer to file a PIL, sometimes lawyers themselves, being the representative of the society, considering the problems in the society, they themselves take up the action and become the petitioner and file the PIL. For example, recently there was a solicitor, Duti Kapadia. In fact, she also realized during the COVID period that what happens to the handicapped people or those senior citizens who cannot go to the vaccination centers for getting the vaccine, what should be done in that case. So considering that PIL, the court did pass an order directing the authorities to form some kind of some modus operandi, so that those people who couldn't step out of the houses because of some disability, weakness, or old age, they could also take up the vaccines at their residence. Now, coming to the drafting part. So when I say newspaper article getting converted into a PIL, a letter getting converted into PIL, we are not concerned for the time being, unless we are on the other side defending either the government or any person who is made party to those proceedings. So our scope, to the extent of present topic, is confined to the public interest litigation filed using the wakalatnama of an advocate, and what are the things that he has to do. So the first thing, having understood the concept of PIL, we must understand that what are the procedures which are laid down by the courts. Normally, when we see that when it comes to filing a suit, we have a CPC in place, we have certain other contract, law of contract in place. But when it comes to filing a PIL, the major two documents, the two legislations that we need to work out and bear in mind is number one, Constitution of India, more particularly Article 32, Article 21, which talks about the personal liberty, 3, Article 226, which talks about various writs, 5 writs that we talk about. So, in order to file a writ, what exactly we have to do? It is basically a simple petition, simple writ petition. But then, in addition to those averments that you make in a simple petition, there are certain specific and special averments that needs to be made in the PIL. What would be that? And where do we get those authorities from? So, there's a Bombay High Court. In case of Bombay High Court, they have framed certain rules. That is called Bombay High Court Public Interest Litigation Rule 2020 to 2010. So basically, this High Court rules were framed pursuant to the judgment of Supreme Court in the case of State of Uttaranchal versus Balwant Singh. And because what is to happen, many vested interest person, motivated people, they to file PIL to get some kind of undue advantage out of the system by putting the state government into machinery into action. And instead of the public at large getting the advantage, there was some group of persons having vested interest used to get the benefits. Therefore, the Honorable Supreme Court had directed all the state high courts to frame the rules and to regulate it in letter and spirit, so that the petition which is converted or which is filed as PIL are completely having necessary ingredients for the court to consider. So now when I say this Bombay High Court public litigation rules, I'll just read out the provisions, basically rule number 4, which says initiation, commencement, lodgement of public litigation. So when we draft it, definitely rule 4 will have to come into play. A public litigation, rule 4.2 says, a public interest litigation petition may commence in any of the following manners. So as I said earlier, that the petition PIL can commence in various modes. So there are 5 modes which are provided in the rule itself. For example, number 1, a suo motu petition in pursuance of the order of Chief Justice or his nominee. So therefore, when I said that the based on the newspaper articles, the Chief Justice comes to it comes to the knowledge of Chief Justice, he can take a suo motu action. Second, as you also know that in the matter when the COVID came into place, that time all the courts were closed, and therefore the court had taken suo motu action, and they passed order under section 142 of the Constitution of India by staying the limitation. That also was in the interest of public and in the form of PIL. Second PIL can be converted in the form of some recommendation for another judge. For example, any other judge who's handling a writ petition not being a PIL comes to conclusion that the matter involves substantial question of law and for the public. Therefore, he may recommend to the Honorable Chief Justice for converting the said petition into PIL. So this is second. Third is, as I said earlier, the letter. This letter could be from any citizen of India or a lawyer's body having some kind of interest. He'll have to disclose as to how he's interested in that, and he can send a letter to the Chief Justice directly. Fourthly, a petition may be directed to be treated as public interest litigation petition by a judicial or a order passed by the court. Any court, irrespective of what he does or whether he refers to the Chief Justice or not. Suppose that the Honorable Judge hearing any particular matter himself comes to conclusion that there is some kind of public interest involved in the matter, he can directly convert that particular writ petition as a public interest litigation. And lastly, as I said, on presentation of a petition in the court in the prescribed pro forma in accordance with the rules. So therefore, as I said, since the topic is presently as to how the petition in the court needs to be filed, therefore the pro forma or the format is already given in the rules. Now, irrespective of that, what are the things are broadly required to be considered for drafting the petition? As we all know that any petition, the petitioner will have to disclose name, postal address, email address, phone number, proof regarding personal identification. It's all in the rule. Rule 5 provides what are the things that needs to be in the petition. So his name, postal address, and other details. Second, facts constituting the cause of action. Why did he come to the court? What happened? What is the necessity of coming to the court? Why? Then thirdly, the nature of injury caused to or likely to be caused to the public. If any injury or any prejudice which is caused to a particular individual, definitely it cannot be converted into PIL or be treated as such. But he'll have to make out a case as to what is the nature of injury caused and how that particular injury is likely to be caused to the public. So he'll have to make a detailed averment to that effect. Then now, once you file a PIL, either through a lawyer or in person, in all cases, that gentleman will have to make out a case as to whether what is his interest. Sometimes, and more often that we all see that in the lines of petitions, the PILs which is filed, whether we come across in a day-to-day matters listed on the board, many of the petition would be in this kind of category where there'll be a people will be motivated. But then still, despite that fact, he'll have to make out a case as to what is his interest. Normally, if you are not interested, you can always write in the petition that I have got nothing to do with the petition, but since I'm concerned for the benefit of the public interest because of XYZ injustice or some malpractice going on or what some kind of ill practice which is prevailing in a particular section of the societies or some kind of wrongdoing is happening, and I am not either, I'll have to say as a petitioner some kind of averment that I am also directly substantially involved, number one. And if I'm not directly substantially involved, I am basically the kind of caretaker and I'm really concerned for the cause of the public interest. Therefore, I have come to the court to file the present petition. That averment, these are the statutory averment. There's no option. If you don't provide these averments, your petition is not going to be admitted in the first place. It will never reach the court of law. Then details of regarding any civil, criminal or revenue litigation involving the petitioner. So therefore, because Supreme Court has said that any person who coming to the court in general has to come with a clean hands. But in the matter of PIL, there's a greater responsibility is cast upon the petitioner that he must be completely bloat free. He must not have any kind of stain on his collar. So therefore, he will have to disclose whether any civil case is pending against him, whether criminal proceedings are pending against him, whether revenue litigation is pending against him. So therefore, he should be an ideal citizen, which should be not interested or should not be kind of any debarred as far as the any litigation is concerned. And then personal locus standi. What is this locus standi? Because locus standi, every time, suppose a PIL comes, in the defense, by default, when the reply is filed by the state or the other side, the respondent, they'll simply say that this person does not have a petitioner does not have locus standi. So in that case, a detailed government will have to be made out so that it becomes difficult for the other side to especially take a technical objections on the basis of that the person does not have locus standi. So now what are the scrutiny? Once a PIL is filed in the registry, the prothonotary is given powers to scrutinize meticulously each and every averment and have to see that whether the petition is in accordance with the rules framed by the Honorable High Court. And once he is satisfied that all the ingredients, all the averments, the formatting, everything is complete, then and in the opinion of the prothonotary, such kind of petition can be treated as a public interest litigation, then he has to simply get it numbered and he'll have to move forward. Otherwise, in case he is not satisfied after going through the pleadings and the averments and the document annex, then he will simply give his opinion and place before the concerned judge with his objections or queries, whatever it is, and the court will consider at that point of time, based on the averment, whether the such petitions is fit to be treated as public interest litigation. Now, that happens as far as the drafting part is concerned. Now, what are the material that you need to annex? Number one, you have to annex an affidavit stating that this all as per the rule 7. I'm saying, what are the annexures? These are mandatory annexures. The petitioners will have to annex to the petition an affidavit stating that there is no personal gain, private motive or oblique in filing the petition. 2, file an affidavit undertaking to pay cost as ordered by the court if it is ultimately held that petitioner is frivolous or has been filed for extraneous consideration or it lacks any bona fide. C, file an undertaking that he will disclose the source of his information. Sometimes what happens, based on certain hearsay, without any credible information, you go to the court and you expect the court to pass a verdict by treating that information as gospel truth. In that case, it is not correct. You will have to come up with some kind of credible information. If not, we have RTI, we have other newspaper articles, which is basically newspaper articles cannot be a basis per se for filing PIL. But when you look at other things supported by the facts which is prevailing, of course, the court can take into consideration, because court is not, in spite of the rules being framed, court is not confined to the formatting or the procedures or the technicalities as far as grant of relief, because ultimately the public interest is of paramount importance. Then if he's, for example, if he's a office bearer of any society, trust or any association, the petition has to be supported by his some authorization. Now, why these disclosures are important? The disclosures are important in the light of the observation and the malpractice which was felt by the honorable courts, that many frivolous petitions were being filed just for the sake of it. Therefore, to curb such malpractice and to weed out such kind of frivolous people from coming to the court and wasting the court time and also the department's time, etc., these petitions, in the petition, these affidavits, undertaking and the cost, everything became a mandatory provision. So now we must have come across so many times that some frivolous petition is filed and the court found that no case was made out and the court has granted exemplary cost. Now, what is important is just not the imposition of mandatory cost. Order rule sorry, the rule 11 of the public interest litigation rules provide that if the court comes to the conclusion, even after the going through the contents of the petition as well as the undertaking filed, or from any other material which is set on record, that the petition was filed with oblique motive or did not have any bona fide, then the court can pass exemplary cost. Exemplary cost is not the cost that we normally find in the case of civil proceedings where the cost is avoided 5,000, 4,000, 10,000. Here, exemplary cost means exemplary cost. It can reach up to crores of rupees depending on the facts and circumstances of the case. And it's not that if you don't pay the cost, you'll get away with it. If you don't pay the cost, the rule provides that cost will be recovered as arrears of land revenue. So we must understand when we go to draft a PIL, when our client comes to us to file a PIL, then all the things will have to be borne in mind. Now, this is the criteria as far as the filing of PIL is concerned. Now, as a lawyer, what are things that we can take into consideration, which is not mentioned here? That is based on the practice, based on the experience, and based on the decided case laws which are there. So what is important for any person, a lawyer, to file a PIL? First of all, he has to make a complete research, because the aim of PIL is to give common people access to the courts. So therefore, any individual who does not have any resource or money or wherewithal or the contact with the good lawyers, it becomes very difficult for them to succeed. Now, so therefore, in order to make out a case for successful PIL, that is the purpose of the present discussion.
Mr. Verma,
what are the things
can you please
to do?
switch
Number
on
one,
the video, please?
sorry, I can't hear you. Hello? Hello? Am I audible? Hello? 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 Am I audible? Hello? Hello?
Yeah, Mr. Verma.
Yeah, I can hear. Can you hear? Am I audible? Am I audible?
Yeah, we can see you.
Can you hear me? Am I audible? Okay, I'll continue. If you can hear me, just raise your hand, please. Hello. Okay. So what is important now today that I was going to discuss, that now we know
Mr.
what is a
Verma,
yeah. Yes. Not audible. I'm not. Is it audible? I log in once again.
yes,
Now.
yes. Please go
Now.
ahead.
Yeah. Sorry. So now, having discussed what is PIL, what are the
No,
formats?
no, no. Please go ahead. No.
Yeah. Okay. So now I've already discussed what constitutes PIL, what are the criteria that one has to bear in mind, what are the procedures and formats that is required under the relevant rules. Now, next topic that I'm going to talk about is, in spite of having so much format and all that, what is important ultimately is to get the success in the court of law. So in order to get a success in the court of law, in spite of having formulated your thought process, having drafted the necessary petition in accordance with the rules, and providing for all the necessary annexures, the the moot point is a little bit of hard work that is necessary, that is very important. So first thing to start with, collection of information. Now, for example, I will just give example of the present PIL, which I just appeared. Basically, the present PIL was filed by two IIT researchers, and from their window, they could see that certain construction was going on with full swing around the periphery of the Powai Lake. Their understanding was that Powai Lake is a wetland which is protected under the National Wetland Atlas in the map. So therefore, Powai Lake, Vihar Lake, all those things are protected wetland, and the law says no construction of whatsoever nature is permitted around the Powai Lake. So these researchers started looking for the information. First of all, they could get the idea what exactly is the rules and regulations which are applicable. So there were guidelines which came across that the Union of India has come up with certain rules, regulations, guidelines as to how these wetlands are to be protected, how the government has to function, how the state government has to function, what is the division of powers and functions between the state government, what are the prohibited areas, what are the restricted areas, what is the wise use of the land. All the things are provided. So therefore, the first job was to collect information. So when you say collect information, means fact finding. So you have located the facts. So once you have located the facts, what is the second thing? It has to be translated into a document, because merely by giving an oral plea is going to be of no help at all. So facts, how do you plead the facts? Just by oral pleading may not really help. Whatever facts that you state has to be supported by documents, has to be supported by photographs. For example, in the present case, when the construction was going on, in fact, the stand which was taken by municipal corporation was that no, we are not carrying out any construction activities. We are just doing a little bit of land filling, and then it is a porous. No water will not get locked into the area, and there's not going to be a shortage of catchment water catchment capacity of the Powai Lake. All the things are started, and just because there were certain photographs which are attached to the petition, and the attention of the court was brought immediately to these photographs, the court came to conclusion that this is something like a road. This is not a kind of the argument which the other side is saying. So I was coming to that. You must do a good research on the facts. Facts should be supported by necessary document. Thirdly, if you are able to support the facts by photographs, videos, it's well and good, because one document speaks for itself, because then immediately the court is not going to go and see the site. He will look at the site, he will look at those aspects, and he will get those ideas. Suppose there are multiple newspaper cuttings published over a period of time in various newspapers, you can make a separate compilation. If not by way of in the petition, you can attach that also, either directly or by a separate compilation. Then third thing is, you must decide which court you need to file. Normally when you file in the basically when we go to the high court, therefore still you get one window. If at all something you get rejected, at least you go to Supreme Court. But in the high court, PIL is also taken to be analogous to the writ petition, where all the not only the fundamental rights can be enforced, but also the writ petitions which were otherwise available for an individual in the case of private writ petitions are also by default available to the petitioners, who is the petitioner of public interest litigation. Then now what is important facts is that we have to also take into consideration that the what reliefs that you are framing, because unless the reliefs are clearly framed, it becomes very difficult for the judge to understand what exactly you're looking at. Although, as we see that in the case of newspaper articles, in the case of letter issued address to the Chief Justice, there you don't seek any relief. You just come up with your grievance and tell that these are the problems. And then court formulates on its own the relief that is be framed. And as I said earlier, in the case of PIL, court is not bound by the technicalities. Court is not bound by the procedural aspects, not any rules of procedure, civil procedure, this and that. Court will simply look into what is the nature of grievance that is made out before the court. It is so grave that ultimately the public interest is at peril. Fourthly, whatever that needs to be done to cure that remedy, to cure the defect, one has to sort that out. Now, what happens in the case of private individuals who are poor? Sometimes, when I said that you have to go with the court with complete research material, sometimes what happens in case of a poor individual, he does not have, because all the informations are with the government most of the time. Sometimes even under RTI Act also they don't share the information. Then what do you do? In that case also Supreme Court has come to the rescue of such cases, that in the case the petitioner or the litigant who is not able to get the document because of the adamant attitude of the public authorities, and he has got no resources, definitely courts have come to the rescue in PIL and have ordered couple of directions. Number one, directing the authorities to supply the documents. Second, if any local inspection is required to be done, as we see in the case of commissioner appointment of commissioner in the CPC, that power is also granted, conferred upon the honorable courts to do a local investigation and arrive at the truth of the matter, and then you pass a judgment. So when I said that, but then that should be the last resort. We should not leave something to the court to do all those things. We should come with the watertight case, a very lucid, not very bulky, so that court can definitely understand and pass judgment based on the document. But as I said, in certain cases, when you don't have the information, we don't have the recourse, and which cannot be made available unless with the great hardships, and all informations are lying in the third party domain, or they are not coming to you, still court can come to your rescue. So therefore, your relief, the prayer that you're seeking, has to be very clear cut, what exactly you're looking at, so that court comes to the conclusion as to how the reliefs are to be granted. But again, I told you that court is not bound by the rules, or even if your prayers are not very formulated very clearly, court can pass all judgments, all orders as you can think about. I think more or less I've covered the law as far as the PIL is concerned. If anyone has got any queries or questions, I may certainly look at. Thank you. You're not audible. I think I can't hear you.
Can you hear me now?
Yeah, I can hear you now. Yes.
Yeah. Now there are certain questions. Thank you for the for your so much deep study and information on PIL. But we have seen many times court past strictures on PIL filed by various litigants or applicant. The main thing is sometimes they just file PIL on the basis of paper cutting, and that is the first question: can such PIL be is maintainable? Number two is any deposit to be made at the time of filing of PIL by way of a security? And thirdly, it can be filed by anyone, or it should be by a reputed person, because whatever I have read for so many years, that the PL is filed by some social activist or a leader or an ex-police officer, like that. So these are the three questions, and I just want to know that what is the constitutional provision you have mentioned in your detail in your speech, and the lecture. But then I just want to know that many a times strictures are passed. So what is the reason behind it? These are the three questions.
See, a couple of things. Strictures are passed because the person who has not been able to make out a case, that could be one of the ground. Number one, your petition does not disclose much, because ultimately, as we all know that let's look at the kind of draw analysis in the case of order 39 rule 1 application in the matter of notice of motion when we go for interim relief, because a prima facie case will have to be made out. And since the constitutional provision also comes that anybody who approaches the court has to go with the clean hands. So the person who's filing the PIL, his credentials are also important, because just anybody who going to the court may not even recognize him. And court is also ultimately they're loaded with work. Their entire board is loaded. So therefore, they will also expect some kind of help from the litigants, either in the form of pleadings or certain material. If those materials are lacking, in that case, definitely the strictures are passed, because you are not only come up with a frivolous case, not complete case, you may have a ground, and you're not able to convince the judge, because ultimately you have to convince the judge that whatever ingredients which constitutes filing of PIL and grant of relief by the court will have to be made out. That is one of the major aspect. And secondly, once you have made out a case for PIL, then the credentials of the person who's filed become secondary, because you are just one. Ultimately, you're representing the public at large. So court may ignore it. But then unless and until court, because ultimately PIL, the grounds made out, the issues raised therein is of paramount importance. Now, coming to newspaper cutting. A newspaper cutting, we all know that it is not reliable as far as the evidence is concerned. But in the matter of PIL, definitely court can take into consideration these aspects, because court is not bound by the procedures. And but then this cannot be taken as a practice, that we all know that there are certain publications, media houses, they're all sponsored sometimes. They act at the behest of someone. So what is important is not because of some opinion which is expressed by someone you can build up your PIL, but on the facts, glaring facts with certain photographs. Because whole idea is that you have to make out a prima facie case. You have to bring out the issue of public interest, how the public interest is prejudiced at large. These are the basic criteria, and all the criteria, as I said, will definitely take a second seat. Thirdly, how you place these matters before the court. That is also important. Sometimes a good PIL has lost because of bad pleading, bad drafting, procedural problems, and sometimes it all depends on the judge also. We all know that, because how sensitive he is to the public cause, that also we have to understand. So I'll not comment on that, but then it all depends on the judge to judge, because sometimes instead of, now, as I said, once you have filed a PIL, you cannot withdraw it. What does it mean? That means you've come to the court, although you as an individual have come before the court, but ultimately, since you're representing the public, court will not easily allow you to withdraw. He will substitute another person to be the petitioner. And in that case, ultimately, the cause which you have come up before the court will have to be adjudicated by the court, and not the litigation raised by a single individual in the form of public interest. Your voice is again not audible.
And about that deposit question on deposit amount while filing of
Yes,
the,
yes.
yeah.
That as far as the deposit concerned, when you file a PIL, nominal charges of 50 or 100 rupees court fees that is a requirement. Okay. Apart from that, you have to give an undertaking in the form of rules, which rules provide that in case your case is found to be frivolous and all that, then you are give undertaking to bear and pay the cost. So that undertaking is there in any case inbuilt in the petition. Therefore, when you go to the court, you make it very express undertaking to the court that, look, if I am by petition turns out to be frivolous, I am bound to pay the cost. Sometimes what happens, because of the delay in the litigation, we have to go the process, because once you file a PIL, it comes for admission. At the time of admission, you don't set out the entire case. Court is also not interested in hearing your case on merits, because you set out a case. Ultimately, the respondents, who are mainly all the government bodies, the state government, the Union of India, all those governments definitely make up our bodies. So they need to file a reply, you need to file a rejoinder. So pending all those procedures taking place, you have to satisfy the court. And once the court is satisfied with the grievance that made out by you and find some kind of ray of hope in your petition, court will allow that petition, admit it without asking for deposit. But if there's some gray area, then there's a difficulty.
And sir, how long it takes from to for admission to disposal? I mean, because there are
See,
so many litigations pending, and we have, I think, 4 million petitions and suits are pending. In such case,
See, I'll
I
tell
mean,
you, I'll tell you, it's not only because there's no deadline given in the, because normally we have a consumer court cases, it has been disposed of in 6 months, 138 provisions are to be disposed of 6 months, RERA provisions, they has to be disposed of within time frame, although it doesn't happen. But as far as the PIL is concerned, there's no time frame or limitation aspect that is either prescribed by the statute or any other thing. So what exactly happens here? One has to be more forceful, okay? Because sometimes what happens, we file the PIL, and what I'm saying is also applies to suit and other proceedings also. If you just file your suit or writ petitions or PIL and you sleep over it, the matter is not going to come to the before the judge automatically. You have to keep on pressurizing the judge. You have to look for the opportunities. You suppose today you have mentioned the matter before the court. You have expressed the urgency for taking the matter on record. You mention the matter. Let it come on the board. Sometimes judge will say that okay, I'll adjourn it to, let's say I'll keep it on. You ask for 7th of May or 7th of June. Judge keeps it on 24th of June. On 24th of June, what happens? The matter is listed very low. And if you are very much convinced that my matter is very important of public importance, you they be there on 24th June immediately. Mention the matter at in the morning. You tell the court that this matter is listed at seal number 87. It will not reach. My lord had considered the matter to be kept on 24th based on my earlier application. Now it will not reach, my lords. The entire petition will become infructuous. So you have to make out urgency. If you're not able to make out urgency, then you're gone. For
okay,
example, in the case of the construction of cycle track along the Powai Lake, the work was still going on. So urgency was there inbuilt. So as a result of which, although the in the usual court we didn't get the opportunity to place the matter before the court, but when it came up before the vacation batch, immediately on the very first day we got the stay.
oh,
So
that
these are
is
the things, and
okay.
we were lucky that this matter got over in, let's say, 7 months,
Oh, okay.
because the issue was very short. All pleadings were completed. Sometimes what happens, the governments take so much of time in filing the replies, and they come with all bulky documents. Then you take time, the matter will not come up. So, but one has to be very forceful. Go to the court. If any time frame is prescribed, keep pushing the departments. That's how you'll be able to do it. And not only for writ, for PILs, even if you apply the same principle, you can get the judgment, I think, within 4 years, 3 years.
Oh, oh, oh.
Yeah.
Okay. Thank you, Mr. Verma. There are no more questions I can see. And now, so narration and to summarize what Mr. Verma has said about PIL is it's a very fast remedy if there is any public wrong is going on, and anyone can file. You have to give an undertaking to the court that if it is frivolous, you have to bear the cost of filing this petition. Once petition is filed, it cannot be withdrawn. Court will substitute the petitioner instead of, if you wish to withdraw as a petitioner, but since it is a public cause, it cannot be withdrawn. And according to Mr. Verma, it is you have to be forceful. Every lawyer tries very hard to get order for his client, of course, but since this is a public cause, one has to be very vigilant. And yeah, and he also said that on the basis of paper cutting, you can file, but there has to be evidence corroborative to those paper cuttings. You just can't file PIL on the basis of paper cuttings. There has to be some evidences like photographs or other affidavits or documents. Without that, on the basis of paper cuttings, you might lose. We have seen during Corona, everything was monitored through court, right from supply of gas to remdesivir to vaccination, and these are the area of operation of PIL is very wide, that we have learned from Mr. Verma. And thank you, Mr. Verma, and thank you all of you for being with us and hearing us. Please do comment and give your feedback, and we shall be back with new other topic to be discussed for all of us. Thank you. Thank you,
Thank you
Mr.
so much.
Verma.
Thank you so much, ma'am. Thank you so much.